Welcome to the Bells I Hear podcast. We will speak with experts who will debunk the myths and misconceptions surrounding homelessness and highlight the innovative approaches for addressing the issues, causes, and consequences of housing insecurity. I am Elisa Smith, your host, a mentor, professor of legal studies, and former public defender. Thanks for tuning in to the Bells I Hear. Today on the Bells I Hear, we're hosting our third segment in our series exploring the intersections of law and homelessness. In this episode, we are focusing on the criminalization of activities related to poverty and homelessness. To help us understand how laws are criminalizing behaviors linked to poverty and homelessness, why these laws are likely ineffective and maybe even unconstitutional, and what policy alternatives might be more effective, we are joined today by two experts, Kirsten Anderson and Matt Wechter. Kirsten is the Deputy Legal Director of Economic Justice at the Southern Poverty Law Center, based in Florida, and Matt is the Deputy Public Defender and the Director of Homeless Court in San Diego, California. Both work as advocates for eliminating inequality and reducing criminalization of people experiencing poverty and homelessness. Thank you for both being here.
Thanks for having us.
Great.
It's good to be here.
It's wonderful to have you talk about this really important topic. Both of you are involved with the ABA Commission on Homelessness and Poverty. So I'd like to get started with two things. One, defining what it means to criminalize homelessness. And second, what the commission is working on to bring those issues to light. And either one of you can start.
Okay, great. I will start. So the criminalization of homelessness is a term that we use to describe the way in which the government, either the federal, state, local governments, use their police powers to punish people who are experiencing homelessness for engaging in basic life-sustaining conduct that is essential to survival. So these are things that are really private behaviors that when done inside of a house are lawful, but when done outside are criminalized. So that can be things like sleeping or camping ordinances, loitering, sitting down, lying down, resting in public places. But it can also include other things like asking for help or ordinances that are targeted at people who are trying to assist people experiencing homelessness, for example, sharing food or offering other aid or comfort to people in public spaces. And it also includes kind of broader police powers outside of even the criminal justice system when we see things like the health department or codes enforcement or other arms of the government that come in and try to remove encampments, do sweeps in public places, destroy people's personal property, things of that nature.
Thank you. So it's pretty broad. There's a lot of activities that fall under this umbrella. Matt, can you tell us a little bit about what the commission is doing to bring these issues to light and work through these issues?
Sure. I mean, the ABA Commission has been kind of on the forefront, and I say the ABA Commission on Homelessness and Poverty. Has been on the forefront of trying to examine a lot of these issues, both from the policy aspect as well as the kind of on the ground, boots on the ground aspect. I just want to start by saying I'm here speaking on my personal behalf, not on behalf of my office or the County of San Diego. This is me speaking personally. And the work that the ABA has done, it's with homeless court specifically, which is kind of where I come in, that started in San Diego, back in 1988. And it really is a way to make it so that folks that are experiencing homelessness that might have justice system involvement can find a way out of that. And so I think, to your question, what does the commission do? And I think that's why it's good that Kirsten and I are both on, is that we deal with kind of the two sides of the coin. There's the policy end, and then there's the on the ground end to try to eliminate the barriers that those particular types of ordinances might create for an individual. So the commission really is looking at both sides of that coin and trying to educate and provide technical assistance for jurisdictions and for individuals across the country in that area.
Great. And so there's some movement toward decriminalization and removing those barriers. Can you tell me a little bit more about what the Commission is doing to reduce those barriers and decriminalize?
I can start us off with one of the things that our Commission did recently. We proposed and had a resolution passed by the ABA House of Delegates. And this resolution reaffirms the American Bar Association's continued opposition to the criminalization of otherwise non-criminal life-sustaining activities that are engaged in by people experiencing homelessness. And the Commission's work, is really focused on improving systems, removing legal barriers to housing, employment, treatment, and vital services. And this resolution was kind of part of that effort to continue to support approaches that uphold dignity and human rights, while also addressing the root causes of homelessness that are impacting kind of some of our most vulnerable neighbors.
Yes. And a resolution for people who might not have a background in the legal system and the law, what exactly is the effect of a resolution?
The resolution is basically a policy statement by the American Bar Association, and it allows the association to take actions because it's kind of a position statement of the Bar Association. And in the resolution itself, what the ABA specifically says is that it's opposing the enactment, enforcement, and supporting the repeal of laws, policies, and practices that are punishing or penalizing people experiencing homelessness. But it also talks, more about those kinds of laws that are targeted specifically at homeless people, like we discussed. It also includes things like the arbitrary enforcement of laws that are kind of generally applicable to the public, so things like trespass, would be a good example, and really supporting the use of non-carceral measures to address issues such as like public health or safety or sanitation concerns.
And the ABA, in order for whether it be the Commission, whether it be any of the other many sections, divisions, and entities of the American Bar Association, they really can't speak publicly on an issue unless there is policy. So anytime there is any sort of issue where the Commission or a different section wants to really advocate on behalf of a particular issue on one way or the other, a resolution has to come before the American Bar Association House of Delegates, which is several hundred people large, that meets twice a year to vote on these types of things. And it's a very extensive process that gets put out usually months in advance, where there's position papers, things like that for people to read ahead of time.
Another tool that, Matt, that you've talked to me about, and that is this pop-up. You have these pop-up approach to addressing housing issues. Can you tell me a little bit about this new approach to addressing housing insecurity?
Sure. Well, it actually starts a little bit, to give a little bit of context, that the Homeless Court Initiative in and of itself, that's been around for almost over 30 years now, really is a way for folks that are experiencing homelessness, that are addressing that root cause, whatever that root cause may be. And as we know, there are many different causes of someone being unhoused. So if they are taking those steps to address it, it's a way for the court to recognize that in terms of a graduation and allow them to escape those fines and fees, have those cases dismissed so that they aren't barriers, right? It doesn't do a person a whole lot of good to go through, whether it be residential drug treatment, mental health, or just the path of getting housing itself, right? Even if there are no other barriers, to then have $3,000 of debt from a misdemeanor case or trolley tickets that they were riding at night because they were scared to stay on the street. So that's been around for a long time. What we learned during COVID, as we know, the court system moves very slowly. But what we learned during COVID is that we can leave the courthouse. We can do things remotely because during COVID we had to. And so we found that instead of just waiting for folks that are in the encampments that are, under the shadow of these particular ordinances or crimes or old criminal history, or even if they don't have anything, they're just scared to come in. This allowed the court to go into the community to say, look, if you come out of the shadows, if you come and talk to us and ask us questions and attempt to address those root causes, we will start that process of helping you. And it's a lot lower of a barrier. And what we found is that resource fairs are going on all the time. They're not new. What is new is the court joining those resource fairs and bringing the weight of the court system out into a parking lot next to an encampment to make it so folks have a lower barrier to engage.
Right. Well, I mean, it's a barrier just to get to a courthouse. People can't necessarily afford to take time, a bus, public transportation, or in some places there is no public transportation to get to a courthouse. To pivot a little bit, the United States Supreme Court just rendered a decision not that long ago in the city of Grants Pass versus Johnson. Kirsten, I was wondering if you might be able to talk to us a little bit about that case. What was the issue? What did the court hold?
Yes, that case came out of this town in Oregon and had gone all the way up through the federal appeals court and ended up in the U.S. Supreme Court after the homeless plaintiffs who had brought the case had won at every point in which courts had heard their argument that arresting them for sleeping or camping on public property is a cruel or unusual punishment in violation of the Eighth Amendment. And so the idea is that a person who is experiencing homelessness is a human being, and all human beings need sleep. Sleep is life-sustaining in the sense that it must occur at some place and at some time. Human beings are built for a 24-hour sleep-wake cycle. We all have to sleep. And so when you make it a crime, in this case, camping was sleeping outside with as little as a blanket to keep yourself warm. And that was punishable with fines, trespass warnings, and ultimately an arrest. And so the idea is that when you make it a crime to sleep outside, you are punishing the status of homelessness itself. And that case was presented to the Supreme Court in 2024, and a decision was rendered in June of that year. And the court disagreed with the plaintiffs and reversed the lower court decision and found that the cruel or unusual punishments clause deals with the allowable punishments after a conviction and doesn't really address the bounds of what a state might criminalize and really focused a lot on the fact that homelessness was a policy issue that was affecting many states and cities across the country, and that they were telling the court, in fact there was a bipartisan group of states and cities that had told the court that the ability to arrest people for sleeping outside was a tool in the policy toolbox that they needed to be able to address this issue. I think what we are seeing in the aftermath of this decision, that was grossly incorrect. We have just seen this explosion of sleeping and camping laws across the country. We're seeing it being passed at state legislative levels, at cities and counties all across the country. It's become part of the federal government's response to homelessness, and they've been promoting it in executive orders and in funding applications and funding requirements. And it is not addressing the reasons why people are sleeping outside. It's not addressing the housing affordability crisis. And really, it just continues to make things worse because now people still don't have housing, but they're released with fines, fees, and a criminal record.
And that goes back to what Matt was talking about in terms of trying to reduce those barriers. What happened after the Johnson case is that they've erected even more barriers. And now it sounds like it's not just one tool, it's becoming the tool in the toolbox, that they're using it so often across the United States in all these large and small cities to address this issue.
And we find, to be honest, as we talk through the commission with a lot of different jurisdictions, even those jurisdictions that enact these ordinances, whether it be city, state, county, whatever it may be, at the end of the day, you have a county sheriff or a police department that is the one that actually has to effectuate that arrest. And a lot of these local law enforcement agencies don't want to use a jail bed, right, that costs money for a low-level crime like this, when they would much rather be housing someone that is committing violent crime. And so there's a lot of back and forth and kind of double-edged swords when jurisdictions are talking about this, and when we, through the commission, do our technical assistance with different jurisdictions, and we meet with sheriffs, and we meet with county board of supervisors, and we meet with prosecutors and defense counsel. It's kind of interesting hearing what they all say, because on one hand, they have their community saying we need to do something about homelessness, right? On the other hand, you have saying, well, we don't necessarily want to arrest people, so what do we do? And I think that's where the commission comes in, and we have our policy end. They can say, look, these are why these policies are good, not good, this is what we recommend. And then, depending on what those policies are, or if they're in the process of changing them, for those clients that have historic barriers, not just the instant case, right, but they have fines and fees, even if they change their policy, they still have these old convictions that are fines and fees that have gone to collections. And when they go to collections, sometimes they go to the Department of Motor Vehicles, they can't get their driver's license, right? There's a lot of those collateral consequences that we try to alleviate through on-the-ground policies at the same time, right? So there's two different sides of that coin that really complement each other for a lot of those jurisdictions that we work with.
Right. And so there's long-term and short-term consequences to criminalizing. And there's also on the other end of the spectrum, there's a lot of benefit, not only to individuals, but to communities in more appropriately addressing this issue. Are there certain groups that are being targeted, and I guess also, are there other cases being litigated to kind of limit the damage that is being done by the Grants Pass Johnson case?
Yes, I'll just say that one of the things the court made very clear is that the Grants Pass case was a limited ruling on a narrow issue, which was simply about the Eighth Amendment's cruel or unusual punishments clause, and whether or not it was cruel or unusual punishment to arrest people for sleeping or camping because it punished the status of homelessness. Now, there are a lot of other constitutional amendments. There's federal ones, there's state ones, and in fact, the court took great pains to go through the fact that there are many other constitutional amendments that apply when the government is policing issues of homelessness and policing people experiencing homelessness. And specifically enumerates the First Amendment, the Fourth Amendment, and so what we are seeing is there is quite a bit of litigation, and there's quite a bit of litigation on all kinds of things. For example, encampment sweeps and encampment closures and evictions is a big one. There's a lot of litigation that goes on, and that generally doesn't involve the Eighth Amendment. It involves the Fourth and the 14th Amendments, and relates to unlawful destruction of property and seizures of people's property. There's also lots of other ways in which cities try to criminalize homelessness, and so there's litigation that goes on in those areas. I've been doing this work for about 20 years, and I have brought cases challenging laws that make it a crime to ask for help. I've challenged trespass laws, food sharing laws, sleeping and camping laws, encampment sweeps, and successfully. And so I think the idea that it's kind of open season, that homelessness has been carved out of the Constitution, that when you lose your housing, you lose your constitutional rights. That is not true. And there are many lawyers working on this issue across the country with organizers and with folks experiencing homelessness who are continuing to assert their legal rights to simply not be punished because of poverty and homelessness.
Right. And in fact, you recently won, or the United States Supreme Court did not accept a case out of Alabama that was argued on First Amendment grounds.
That's right. Our team at the Southern Poverty Law Center had challenged two state statutes in the state of Alabama as being unconstitutional under the First Amendment. They prohibited soliciting charity. So they prohibited people who are experiencing homelessness from holding signs that communicated messages of need that said things like, homeless today, it's me, tomorrow it could be you. And people were getting arrested, fined, jailed for what is protected speech. It's the United States of America. There is nothing I could write on a sign short of some sort of threat or something that is outside the bounds. And so the same laws that protect me and you and our speech protect people who don't have houses. And so that's the principle of the First Amendment that we were operating under. And we won at the district court, and we won at the 11th Circuit Court of Appeals, the Federal Court of Appeals. But the state of Alabama was arguing something a little bit different, which is that at the founding of this country, we had vagrancy laws. And in their view, that poor people really did not enjoy civil and political rights at the time of the Constitution, and therefore the First Amendment should not apply at all. That it was incorrect to analyze the speech of people experiencing homelessness because at the founding of this country, they were quote unquote vagrants. And so this argument was presented to the 11th Circuit, both originally to the panel, and then they asked for what's called a rehearing en banc. So they asked for a hearing of the entire court, and then they petitioned the U.S. Supreme Court on this theory. And there were multiple state attorney generals from other states that filed an amicus brief in support of Alabama's position. But we recently just heard that this U.S. Supreme Court decided not to accept that case. And so what that means is that the decisions that we won in the lower courts will stand, striking down these laws as unconstitutional and violation of our clients' free speech rights. And that is the end of the case. And by the way, that's not an unusual proposition. There was radical agreement among federal appeals courts that this is protected speech. And so we're pleased that the Supreme Court did not seek to overturn the First Amendment for a category of persons in our society.
I just want to say that I think that case really kind of lays out the fact that unhoused people are people too. Right. I say that from the public defender aspect. My job is to make it so that the rest of the system doesn't just see a case number; they see an actual person. And I think that's a lot of what the commission's work does, the homeless court and stuff that I work on does, is trying to say, look, just because they are unhoused or they were unhoused in the past doesn't mean that they don't deserve protection. Doesn't mean they don't deserve relief from some of these fines and fees and convictions that are holding them back. It really is pretty interesting how we're trying to classify them as different, right, or other, when at the same time, yes, what that sign said was right? It's me today, it could be you tomorrow, right? And that's what I think a lot, at least for me, when I watch the news coverage of these pop-up events that we do, or we now call them same-day solutions fairs, I think they're more descriptive.
Yeah.
It's because we're able to get them birth certificates and all those things. When you see the news coverage and they're interviewing folks that are getting help and are coming out of the encampment to get their birth certificate, because you can't do anything without a birth certificate, right? They actually are interviewing them as a real person. And that makes it so that the average individual that's sitting at home watching local news, that normally is driving down the road, and they just think that that person living in the tent, they have to have a drug problem, right? They have to be mentally ill. They have to be something other than me, as opposed to they had a family member get sick and they didn't have their insurance correctly, or whatever it may be. And as a result, now they're on the street. And so I think it's really important that whatever we do, policy end, fighting these cases all the way up to the Supreme Court like Kirsten does, or on the ground, right, for the individual person, we're trying to make it so that we show everyone else that they are human. The collaborative courts judge in San Diego has a quote that I have in my presentation when I talk to other jurisdictions, saying addressing the root cause of someone being unhoused is going to have more benefit than fines, fees, or jail ever will. And I think that's important to recognize it, even if it is a tool in the toolbox, right? That, that's a fight that the Southern Poverty Law Center, is fighting, and the Commission on their policy is fighting. Even if that is a tool, on the tail end, we need to be able to remove that barrier if they are addressing that root cause and trying to pick themselves up by their bootstraps. And that's something that either side of the aisle, I think, can get along with, is if someone is trying to address that, let's help them. They take a step, we take a step.
Yeah, I mean, are the tools effective? I mean, that has to be a foundational question. It could be a tool, but is it an effective tool? And one of the things I hear you both talking about is this evolution. And I always feel like we take 2 steps forward and we take 2 or 3 steps back. And this idea of evolution and it's that originalist idea of going backwards to go forwards. And I'm not sure we're evolving and always in the right direction. But Matt, there has been evolution in the housing court area. I'm not sure how many jurisdictions actually have a housing court, but you've been doing this a while. Can you tell us a little bit about that positive evolution of housing court?
And so the housing court, I think, has more of a connotation of more on the civil eviction side. Mm-hmm. So at least the name of the initiative through the commission is homeless court. There's a lot of reasons why in different jurisdictions that name isn't a great name, right? Because there's a lot of reasons why homeless is not a really good descriptor. So I want to make sure I put that out there, is that I'm not subscribed to that particular title of it. There's street outreach court, they call it in Detroit, homeless and caring court. There's lots of different names for it. So really it's whatever that jurisdiction thinks is appropriate for them. But there are a lot of different varieties of it. There's varieties that aren't necessarily the ABA model, that are what I would call a community court, where it's based on someone having to do volunteer work service or do hours at a thing to pick up trash or whatever it may be. What the homeless court model, and I'll just keep using the word homeless court, understanding that, again, that may not be the best phrase long term.
A little asterisk. We'll have a little asterisk on.
We'll put a little asterisk next to it, because we've talked a lot about that. I was like in our different commission meetings and our other gatherings that we've had a lot of different talk about what is a good name. And for me, I just want to make sure that the person that's on the street knows that they can get help here. But there has been a lot of evolution for that. There's the community courts where they have to do that work at a different, nonprofit where they're doing a volunteer work. There's different, more what I would call a specialty court that's very similar to a drug court or a veteran court, where someone is actually sentenced to a particular specialty court. That's really not what the ABA model does. And when I say ABA model, I mean ABA San Diego model, and that is the actual policy. We were talking about resolutions, right? The ABA policy is supportive of, is that we try to call it a recognition court, is that if someone is addressing that root cause, in whatever way that may be, it can be addressing a drug issue, it can be addressing a mental health issue, but that's just one very small piece of it. It may be that they are working with a housing provider. It may be that they are getting health care. Whatever that may be, getting your ID, getting your social security card, that we have in San Diego County, and understanding we're a larger jurisdiction, we have about 98 at this point approved community providers that can refer or make a recommendation of one of their clients to come in once they've completed specific requirements for that individual program. And so what we think is the best, as we ABA model in the commission in terms of this graduation or this recognition model, is that let's not get the court involved until the person has met those, I'll call them benchmarks. That makes it sound too rigid. Has someone addressed that root cause? And do we have a letter from a case manager that says that they are actually ready to graduate? That's why I use the word graduate. We found that It's less resource intensive for the court, less resource intensive for the community partners. It's not more work for community partners because they're already those case managers that are on the ground, and God bless them, right? They are doing amazing work. This is work they're already doing. And so we're trying to get communities on board with the idea that you don't have to micromanage these individuals, right? Let's point them in the right direction, right? Let's try to help them along their own journey.
Right.
And once they get to that point, let's get those barriers and let them continue on that positive trajectory on their own.
Right. And it sounds like a very individualized approach to addressing the needs of the individuals, as opposed to, the encampment sweeps, which are kind of like a one size fits all to address what is perceived to be the issue, which doesn't address the foundational issue. Kirsten, you've been doing this a while as well, as you've mentioned. Do you think these issues are different today than they have been in the past? I almost feel like these issues are having a moment. Every time I open the newspaper, there's another article, for better or for worse. Sometimes they're positive, sometimes they're not. But is it having a moment, or is it just one of these situations where I'm more aware? So therefore, I see it everywhere. What do you think?
I do agree, unfortunately, that it is having a moment. I think when I first started doing this work, it was hyper-local work. It was cities and counties and sheriffs, and, it would start with some concerned residents, and they would come to the council meeting and say, hey, there's some homeless people. Can we do something about this? And with kind of limited resources, and they were always like, well, we could pass an ordinance, and they kind of go down this pathway to criminalization, and what happens, and I think why there's so many different tactics and ways in which to criminalize, is that you cannot deter people from engaging in activity that is necessary to survive. And so if people have, no choice but to violate these laws, they're going to continue to be homeless when they get released from jail. And so it's just this cycle of displacement and hiding of people from public view, because that's really what we're talking about. We're talking about trying to erase a problem rather than solve it. And the problem that I'm referring is not people, it is a housing system that makes housing affordable for half this country. And so we see this, and we were constantly, dealing with this at the city level. And in the last couple of years, what we have seen is that the tactics and strategies have moved up to the state and federal governments, and in some ways states have taken away powers from cities who don't want to criminalize or are mandating. In Florida, we had a law that was passed where they said that no city or county was allowed to authorize people to regularly sleep outside. And so, well, okay. I mean, so everyone gets a house? Is that what we're saying? And so what we saw instead is that cities and counties were passing these ordinances even when they had declined to do so in the past, because they were kind of being forced to by the state government. And then similarly, we've seen this move into federal politics. We've seen a number of executive orders come out from this administration. By the way, specifically referring to people experiencing homelessness as vagrants, I don't think that's coincidental. The arguments that are being raised by Alabama about vagrancy laws, the use of the term vagrant. Vagrancy law is kind of this ancient Elizabethan poor law idea that somebody who's idle, who's not working, and who is poor, is just a criminal inherently. They're a vagrant, and they could be locked up or put in a poorhouse or forced into involuntary servitude. And they was certainly present at the founding, but then also kind of got renewed life in the South during Reconstruction, and the Black Codes was a tool for subjugation of Black people in particular, to keep them in a state of kind of perpetual economic subjugation. And there are courts saying things like vagrancy laws are the dustbin of the criminal justice system. It's just this catch-all for anyone who's like undesirable by the government. And I think we're seeing those same kinds of arguments be made about other groups, like immigrants, for example. And so, I think it's right that we are having a moment, and I think it's not just about homelessness, but about a bigger political project to redefine citizenship itself and who is under the protection of the law.
Yeah. And I think that's probably a good place to segue into this part of the podcast where we try to address misconceptions and myths, because one of the myths that I hear you talking about is this idea that individuals who are experiencing homelessness are lazy, or they somehow are responsible for their lot in life and their situation, and we can just simply punish them out of, or that it was a choice. Somehow it's a choice. If you're punishing someone, you think they're choosing. And I think those are some myths. But are there any other myths that resonate with the work that you're doing that you think people hold that we want to disabuse them of? Matt, I'll let you go first.
I mean, you kind of touched on it with the lazy. I was going to, when you asked me about this, I was going to say that everyone has a drug problem or a mental health problem. Because there are so many people that I've come across through homeless court, through being a public defender for 16 years now, which is crazy, that they are there not through any fault of their own, right? They are... they've fallen down, I think I indicated earlier, because of a family medical issue. And so I think it's really important that, we recognize that sometimes these things happen. And by the way, even if we're talking about mental health and drug addiction in the same conversation as homelessness, sometimes it's a chicken and an egg situation. Sometimes they may have fallen into homelessness, and then as a result of that, because being homeless is an incredibly traumatic thing. Incredibly traumatic thing to not have a place that is safe to sit your head down, right? I think I mentioned earlier, people riding the bus or riding the trolley at night just to be safe because they can't fall asleep on the sidewalk. Right. That kind of trauma can create a drug addiction. So it's not that one causes the other and that they even always exist together. So I think that if we need to look at those types of things in a more nuanced way, when we're looking at a person, if it was your brother, if it was your sister, if it was your mom or your dad. And sometimes I've had clients where they talk about how it's their mom and their sister and their dad. So it's making sure that we look at them individually.
Yeah. And Kirsten?
One of the myths I would surface is one of the ones that was peddled by the city of Grants Pass before the Supreme Court, which is this idea that there are services available, but people just don't want to avail themselves of it. And so the threat of arrest is sort of this stick that's necessary to get people to accept the carrot of services. And I think this myth was actually really revealed for what it was during the oral arguments when there was an exchange between the attorney for Grants Pass and one of the justices about whether or not there were sufficient beds available, where there were enough services for everybody who was sleeping outside. So you needed to be able to threaten with them with arrest because, there would be help for everyone who needs it. And of course, that's not true. That's the whole point. That's why the plaintiffs had won all along, is that the need far outstripped what was available to people. And so people really had no choice but to be outside. And so I think that myth is really pervasive. And I think that is a bipartisan myth. I have heard that on both sides of the aisle. And this idea that people are service resistant, I've heard that term a lot too. This idea that people would resist safety and dignity and security of a home, I think is just a false one, and we need to stop building our public policy around these kinds of myths.
In a recent article that you wrote, Kirsten, with other co-authors for the ABA Human Rights magazine, there was a call for disentangling homelessness from the criminal legal system, most succinctly stated by saying we need housing, not handcuffs. I'd like to ask both of you, as we're wrapping up, do you think it's possible to disentangle homelessness experiences and criminalization? And where do we go? How do we do that more quickly than I think we're on the path to do? So Matt, you can go first if you'd like.
I hope so. I really hope so. I've been doing this a long time, and I've seen the entire width and breadth of criminal cases. And as a public defender, the majority of my clients are unhoused or at risk of being unhoused. For over 16 years, and working with this population for over 16 years, I think it's going to be hard to overcome, but I have hope. And I have hope that we can continue working to try.
Yeah. Kirsten?
Yes, I think we can do it. I think that, for a lot of people who are getting arrested for the so-called homeless crimes, if you're in a house, you don't need to sleep outside on the sidewalk, for example, right? And so your arrests are going to go down. But I think the question you raised and what Matt just said raises a bigger issue on the entanglement of the criminal justice system with poverty. And the reason, I think we should question why a public defender, most of your clients are, unhoused or at risk of losing their housing. I think that signals something very structurally wrong. And one of the things that people ask me a lot is like, why does this happen? Like, if these laws are so blatantly unconstitutional, why does every city have them on the books? Why are they being passed by legislature after legislature? Like, well, what is going on? And I think you have to look at the fact that these are the least politically powerful people in our society. They're the least likely to be able to get out on bond. And so they're faced with just having to plead guilty so that they can get out of jail. And so that just creates this cycle where a lot of these can't get challenged, really. And so I think things like what Matt is doing are kind of extraordinary methods of trying to disentangle the criminal justice system and realizing that what people need is not found there. It is found through other kinds of social services and supports that we can offer. And I hope that we can start offering them in places other than courts. But sometimes in a lot of communities, that's where the best services have all kind of coalesced, because we're trying to solve for a bigger problem in our society about kind of criminalization of poverty.
Right. Yeah. And, the work I've done is in the misdemeanor courts. And so, you see so many people rotating in and out, and even a short jail stay, they lose, even if they had housing, they lose their housing, they lose their job, they become more indebted. And then the cycle just continues and continues. And so criminalizing these kinds of activities is not the answer.
I think the point that both of you just made is so critical, is that a person being arrested, assuming that you have a sheriff is going to do the arrest, right? a person being arrested for whatever the crime is, but we're talking about lower level crimes here, that is going to disrupt their life. I think in some situations that's what the policy is intended to do, but it's not doing it in a productive way most of the time. I think there's a whole different discussion we can have about pretrial release and making it so we don't have those jail stays. And like I said, that's a conversation for another time that's very near and dear to my heart and other work that I do. But in disentangling the charge and disentangling the arrest, disentangling the actual jail stay, there's so many different steps. And you said that, is it having a moment, right? The pendulum swings, right? Isn't that what we talk about in the criminal justice system? The pendulum swings. Nice. The hope is that when the pendulum swings back the other way, as it often does, and it has for many, many years, that we can capitalize on that and continue to do good work.
Yeah, and that's the work that both of you are doing to get that pendulum going in the right direction, I hope. Well, thank you so much for the conversation, Kirsten and Matt, for joining us today on this episode of The Bells I Hear. We look forward to watching you continue to do this good work. So thank you so much.
Thank you.
Thank you for tuning in to the Bells I Hear podcast. If you enjoyed today's episode, please subscribe to the Bells I Hear and follow us on social media. We post all of our conversations on YouTube, Spotify, and Apple. You can connect with us on Instagram and post comments or questions that we can address on upcoming shows. More information can also be found on Blogger and Substack. So many ways to learn about the issues surrounding housing insecurity. Please join us and contribute to the conversation.